Welcome to Imagine IP, where ancient stories meet modern law. Today we're telling the tale of a trademark Icarus, a family business that built wings of wax and false declarations, soared to legal heights, then crashed spectacularly when they flew too close to the litigation sun. This is the story of Caporaso v Mercato Centrale. Fresh from the Australian federal court, and it's a perfect reminder that in intellectual property law, as in Greek mythology, hubris always demands payment. So grab your coffee, settle in, and let me tell you about the most expensive trademark mistake in recent Australian legal history.
Our story begins in 2016 with the Caporaso family, Italian immigrants who'd built a successful food empire across Australia. Supermarkets, restaurants, wine shops, they were living the immigrant dream. But like Daedalus crafting wings for his son, they decided to build themselves some legal protection. 3 trademark registrations featuring the word Mercato, Italian for market. Here's where our Icarus story begins. When John Caporaso filed for his plain word Mercato trademark, he didn't just submit an application, he crafted a beautiful set of wings made from, well, let's call it creative storytelling. His statutory declaration claimed the family had been using Mercato since the 1970s, starting with a deli called Ima and Mario's Mercato. Poetic, heritage-rich, legally compelling. One tiny problem. It was completely false. The business was actually called Ima and Mario's Continental. They didn't use Mercato standalone until around 2009. The trademark examiner bought the story, accepted the application, and voila, legal wings were attached. Here's the beautiful irony. Trademark was probably registrable anyway. Mercato is inherently distinctive in Australia.
For years, those false wings worked perfectly. The Caporaso family soared through the Australian food market with their registered trademark protection. 3 marks, broad coverage, legal monopoly over Mercato. They felt invincible. Why wouldn't they? The trademark register said they owned the word. The endorsements on their registration even noted the examiner's satisfaction with their history and usage evidence. Life was good in the sky. Then, in 2022, something appeared on the horizon. A new Italian food hall called Mercato Centrale, opening on Melbourne's trendy Collins Street. Not just using Mercato, but boldly, unapologetically, using it without registration. Most businesses might have sent a cease and desist letter, maybe negotiated a coexistence agreement. But remember, our Icarus had been flying high for years. He felt untouchable. Not on our watch, they essentially declared. Time to show these newcomers who rules the Mercato airspace. In 2023, Caporaso filed a trademark infringement lawsuit. This was their moment to soar highest, using their registered rights to crush an unregistered competitor. The full power of federal court litigation backed by trademark monopoly. But here's the thing about flying too close to the sun. It exposes you to scrutiny you might not survive. Mercato Centrale didn't just roll over. They hired serious lawyers and fired back with an explosive cross-claim. Your trademarks shouldn't exist. You lied to get them. Suddenly, that beautiful flight path became very dangerous. Discovery requests started flying. Old business records were subpoenaed. The Daylesford restaurant using Mercato at Daylesford before Caporaso's priority date was discovered. Most damaging of all, John Caporaso's 2016 statutory declaration came under microscopic examination. Every claim, every date, every assertion about business history was forensically analyzed. The wax was starting to melt. During cross-examination, Caporaso had to admit the truth. The 1970s claim? False. The 2005 standalone use? False. The decade of exclusive use? False. But they still had hope. The primary judge took a relatively lenient view. Sure, you lied, but it doesn't matter, because your mark was registrable anyway. Caporaso thought they'd survived their close encounter with the sun. The wings were damaged, but still functional. Time to glide to safety. They were so wrong. Both parties appealed, and that's when Caporaso discovered what happens when Icarus's wings finally fail. The full court of the federal court looked at Section 62B of the Trademarks Act and said something that changed everything. This isn't about whether lies matter to registrability. This is about whether lies matter to the decision-maker's process. And the examiner's notes were crystal clear. combination of applicants' history and usage to date means maintaining objection not warranted. The false representations weren't just relevant. They were material to the entire acceptance decision. The court didn't just trim Caporaso's wings, they ripped them off entirely. Complete cancellation of the plain word Mercato trademark. Gone. Obliterated. The nuclear option. Their reasoning? The integrity of the trademark system matters more than protecting someone who obtained registration through false statements, even about supposedly irrelevant matters. Caporaso had flown too high, exposed themselves to fatal scrutiny, and crashed harder than the original Icarus.
So what's the moral of our modern Icarus tale?
First, don't build your intellectual property empire on wax wings. The Australian courts have made it crystal clear. Honesty in trademark applications isn't optional, it's existential. Even irrelevant lies can destroy your entire registration if they influenced the examiner. Second, sometimes the best legal strategy is knowing when not to fly. Caporaso had a decent business, some trademark protection, and a competitor they probably could have coexisted with. Instead, they chose aggressive litigation that exposed their fatal weakness. Third, the sun in IP law is judicial scrutiny. The higher you fly with questionable practices, the more likely you are to melt under examination. The Caporaso family went from trademark owners to cautionary tale in one spectacular legal crash. They learned what Daedalus tried to teach his son. Artificial advantages built on deception will always fail when tested by the harsh light of truth. Build your trademark portfolio with honesty, not wax. Because in intellectual property law, as in Greek mythology, the gods always collect their due. That's all from us today, and as always, keep imagining.